Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Radio. This is May 25th, 2024. It's a Memorial Day weekend. The song that you were hearing was by a group called Train. The name of the song, Play That Song. And I played Train this today because of a situation which happened to their bass player, Charlie Colin. He died at the age of 58 this last week, and he slipped in the shower. So this is kind of a tribute to him and condolences to his family. And to all the listeners out there, please, whatever you do, don't fall. And quite frankly, certainly don't fall when you get old, because that happened to me last week too. So, and it's not a pretty sight. Okay, let's move on with our show today. We're going to talk about, to begin, late charges. Most rental agreements have late charges, and most people tend to ignore the late charges. They don't try to collect them. And if a tenant owes rent, they're generally going to proceed based on non-payment of rent, and they're going to let kind of forget the late charges since it's minor in comparison with the rent that is owed. But right now I find ourselves, in my practice, of course, using late charges as a proper strategy to evict tenants. And I'll get into that in just a couple of minutes. But the first thing that we have to do is we have to make sure that our rental agreements have a proper late charge. If it doesn't have a proper late charge, then you have no legal obligation, or the tenant doesn't have a legal obligation to collect it. So what is a proper late charge? So what I'm going to do now is I'm going to share the screen, and I'm going to tone in on my rental agreement, which is on my website, evict123.com. And you see it's in paragraph number 11. If your rental agreement says that if you don't pay your rent within 3 days of its due date, then you're going to be charged a late charge in the sum of $50 or 6%. If it says that language only, then you have an improper late charge. There was a case that came down in the appeals court for the state of California, and they stated that you had to have proper language. And if you read what I have written in mine, and you can just copy it if you don't have it in your rental agreement or use my rental agreement, you have to have some language stating that it's not just, quote, a penalty, that there's some actual reason why you're charging this late charge. So as you can see, as I read this to you, that the parties agreed that it would be impractical or extremely difficult to fix the actual amount damaged by the landlord if the tenant fails to pay rent timely. And this is like an administrative cost, which is related to collecting and accounting for late payments. So by having that in in a rental agreement, you are legally allowed to collect late charges. Now, why is that so important today, you might ask? And the reason why it's important today, and I'll move over to this chart here, is because let's pretend in the city of Los Angeles and unincorporated areas of LA County, if you have, for example, a one-bedroom apartment that's going for $2,000, then you can't even serve a 3-day notice until rent is owed for 2 months. So if he didn't pay you the May's rent, that's $2,000. You can't serve it for that one-bedroom apartment because it's below the threshold. Now, again, this only works or is only in jurisdictions of the city of Los Angeles and unincorporated areas of LA County where they have this ridiculous threshold amount. So what happens, in fact, I wrote a question and answer for the Apartment Owners Association, which will actually come out in their July issue, which states that we had this tenant, a person wrote in to me, that pays his rent on the 25th day of each month, the 25th of each month, because he knows you can't serve a 3-day notice because his rent's below $2,000. So In that situation, the landlord has to basically accept the fact that the tenant is paying his rent late, because there's nothing he can do to bring forth an eviction based on non-payment of rent. But as I wrote, you do have other strategies. If you do have a proper late charge in your notice, and he hasn't paid that late charge for 1, 2, 3, 4 months, then what you can do is you can prepare a notice to perform or quit. Now, I've prepared one. This form is on my website. And this is not asking for rent. So it has nothing to do with the threshold. This has to do with the fact that you didn't pay your late charge. So in my example here, you fill it out by stating the tenant's name, the tenant's address, and then we get to the point where it says that the type of violation, and that's pursuant to the terms of the rental agreement, a late charge in the sum of $50 is incurred if rent is not paid within 3 days of the due date. You have failed to pay your rent, which was due on May 1st, 2024, and you continue to haven't paid it until May 25th of 2024 today. Then I go on to say that within the 3 days stated herein, you must pay the sum of $50 to your landlord. If the tenant doesn't pay the $50, you now have a wonderful case for eviction, even though it's only $50. So this is a strategy that you can employ, not just to get your late charge, but it's a strategy that you can employ to actually evict your tenants. And that, ladies and gentlemen, is my topic of the day. And I'm going to open it up now for questions. But remember, if you are a person asking a question, you can do so by electronically raising your hand. That's in the toolbar on your Zoom. For those people who are on YouTube Live, obviously you're not going to be able to interact. You'll just be able to sit back and enjoy the tales of woe from other landlords. Please, when you do ask a question, please try to be concise so that we can get to everybody's questions. If you do have a case with my office, as always, God bless you. But in that case, we want to make sure that you save those questions by calling our office. We're only going to take general questions here, and obviously we're closed on Monday. And last but not least, this Zoom meeting is for informational purposes only. It's not a substitute for legal advice. That notwithstanding, we're going to go in the order that I see here, and we're going to open up with Jim Polina. Please unmute yourself.
Hi, Dennis.
Hello, Jim.
Well, you just made me confused because in your lease, you say that late fees and other advances are considered rent. Then I just heard you say that late fees are not rent.
Okay, funny that you should say that. That is a issue that if you want to have, well, of course, if you're going to, if the tenant's not paying the rent based on my lease, which says that all obligations, financial obligations are considered rent. So on that basis, you could actually add a late charge into a 3-day notice because it is considered rent. If you're below the threshold, that might get you above the threshold because he hasn't paid his rent timely for the last 3 months. So you might want to add that in. That might probably will get you above the threshold. But if you do have that phrase in your rental agreement, then technically it would be considered rent and you would be below the threshold. So you are correct on that. And by the way, I hate you for pointing that out. But it is true. But it might, if you do it the reverse way, the late charge is considered rent if you have that phrase in your rental agreement. So therefore, that might boost you above the threshold.
So how often have you been challenged in court saying that no, late fees, no matter what you write in the lease, you cannot call it rent, even though the tenant agrees to it? Has that ever been challenged, and did you win?
We have won this case numerous times. Now, again, the concept of threshold is is just a recent cancer that the city of Los Angeles and unincorporated areas of LA County have instituted. But we have served double notices, one where we'll serve a 3-day notice for the rent and a 3-day notice to perform or quit. And it's interesting because if you don't have that phrase in your rental agreement that all financial obligations are considered rent, and obviously there's pros for having that and some cons for having that, then if the tenant's claiming habitability, for example, as to the reason why you withhold rent, you can argue successfully that habitability doesn't count for a notice to perform or quit.
Okay. Well, I would like to ask you what my main question was here. I'm in the process of adding an ADU to my house and converting the master into a junior ADU, which comes along with the stipulation, a recorded deed restriction that I have to live in it for life. Well, I could foresee the future where I end up renting it out. And if I do rent it out, would I be in trouble trying to evict in that situation?
I don't know what the procedures are in terms of the fact that they're telling you that for life you have to live in that. That makes absolutely no sense. Even if you're going to do a Ellis Act, that just means that you can't rent out the units for 10 years. So I'm not sure how that would react. I don't think it has any applicability in terms of a tenant eviction, but I'd have to check that statute out. I haven't heard that.
Okay, thank you.
All right, Jim, you have a good weekend. Happy Memorial Day. We're going to move on to Dennis Sibley, my trombonist. How are you, sir?
Oh, doing very nicely, thank you. Particularly had a bout of very sickness, and so is dear Teresa. Question mark, and thank you very much. Question mark. Okay, situation, scenario. Tenant moved on my property, Riverside County, a non-tenant's vehicle that's not operational. I looked at the house rules here. It says that unauthorized parking on premises is subject to towing at a vehicle's owner's expense. I was wondering, I looked at the rental agreement. There's nothing about that. There is a violation of the city code about non-operational vehicles. Question, is it actionable to do a notice to perform, covenant, or quit to have the terms of violation, storing non-tenant vehicle and property, see attached photos, remove vehicle license, from the property? Is that actionable?
And the answer is yes. First of all, you might want to take a look at your rental agreement, and even though it doesn't talk about inoperable cars, it probably states that you're not allowed to violate any local or state law. If it states that, then that would be a direct violation, and you could use that notice to perform or quit, asking him to either remove the inoperable vehicle or make it operational within 3 days. You got to use both languages.
Well,
Now,
yes, excuse me, but it's a non-tenant's vehicle, non-tenant's vehicle.
but the tenant is obviously authorizing him to have it there. You're just not telling me that a stranger is just parking your car there. There has to be some nexus to the person who you lease the premises to, right?
Okay, yes.
Okay, so you're in control of yourself and your invitees. That's number one. Now let's pretend your rental agreement doesn't have any phrase about inoperable vehicles or where you can park the car, and it doesn't state any term stating that you can't violate any law. It's just silent on that. Or let's pretend you don't even have a rental agreement. It's just a verbal rental agreement. Can you do something? Can you use that notice that's in your hand, the notice to perform or quit, and ask the tenant to move? And the answer is yes, but you've got to augment that notice a little bit. So what we write in our notices, it's a notice to perform or quit and abate nuisance, and abate nuisance or quit. You can evict the tenant who's creating a nuisance. And so in this case, the law has defined an inoperable car on your property as being a nuisance. So on that basis, we're telling him to, hey, you got 3 days. And again, you got to use this language. You got 3 days to perform or quit or abate nuisance, to either remove the car from my premises or make it operational all within the 3-day period.
Okay.
All right. Hopefully that answered your question, young sir.
Well, I'd really like to have the car out of there. I don't like non-tenant vehicles on my property. But as you say, if the tenant allowed or assisted to put that non-operational vehicle on the property, then it goes to the tenant and it goes back to the tenant to
The tenant is controlling here.
I
The
understand.
tenant has allowed his invitee to park that car there. So the tenant's the one you're going after, obviously.
Okay, the person doesn't live there. He's not visiting there. He's not even on the premises at all.
But your tenant has allowed this condition to exist. I don't know why you're having a problem with this. Okay. Now, if you're saying, gee, I really don't want to make it operational, I really want him to just get the car off, well, then it's very simple. Get yourself a better rental agreement, okay, the next time you lease it out.
Well, I hope AOA, which is an AOA rental agreement, I hope it
I think there's things in there, so I'd have to take a look at that for you. Anyway, Dennis, thank you for your question. We are going to move on to, let's move on to Ashok Madden. I'm going to ask you to unmute yourself.
Yes, sir. I have a couple of quick questions. Somebody sent a clause. They say, hey, if you have this clause in your rental agreement, which says that tenant is responsible for first $150 worth of repairs. Is that something legal?
I don't think that's enforceable based on the civil code. The landlord is required to take care of his property and make it habitable. So I don't think that's proper. If in fact the tenant negligently damaged your property, then the tenant is responsible for it. But that's a good try. And those kinds of clauses really give landlords a bad name. Your job is to make the premises habitable and to keep it up. Things will obviously wear out. Garbage disposals will go out, electrical panels will have issues and plumbing leaks. That's your responsibility as a landlord, and just build that into the, build that into the rent that you're charging the tenant.
No, we're talking about like smoke detectors, carbon monoxide, and those we keep replacing and they keep breaking them. So,
well, if the tenant breaks the smoke detector, because generally, how is the smoke detector going to break? So either the tenant got mad and took a broom handle to it. So in that respect, that would be the tenant's responsibility, and I would do the repair and make a demand to the tenant to pay for the repair costs. And if he doesn't, then you have grounds to evict. Anyway, thank you very much. We are going to move on. I kind of got out of order here by mistake. So let's move on to Scott Shoemaker. I'm going to ask you to unmute yourself.
Hey, my brother has an apartment building, and he's been involved in trying to evict a tenant for like 4 or 5 months now. And the tenant is doing like all kinds of legal hoops and jumps and stuff and delaying things and stuff. But I just looked at my brother's 3-day pay or quit because I had watched your videos on that. And I see that he included some things like, utilities in his original thing, and he never filed with the LA Housing Department. Should he continue with the suit and hope that the tenant doesn't know, or should he drop it and take him to small claims if it's for COVID?
Well, first of all, if the tenant is litigious and filing all these motions, trust me, he's going to get that out. You're going to lose the case. So I would dismiss this case right now. And then you can either bring forth a new unlawful detainer, or you can try to sue for it in small claims court.
What would the new one be for? What would the new unlawful detainer be for?
I would have to know the facts of the case. If there's current rent.
Oh, just a different thing, not the COVID money.
Oh, I would sue if you're talking. Are you talking about the city of Los Angeles?
Yeah, downtown LA.
Okay, I would ask for any rent that became due within the last year. So right now we're in May of 2024. I would ask for any rent that became due from June of 2023 through the end of this month.
Okay.
All right, thank you very much. We are moving on to Austin. Austin, how are you? Unmute yourself, please.
Hello, Dennis. Thank you. Thank you for taking my question. My girlfriend lives in Huntington Beach in Orange County, and she owns a two-bed condo. She wants to rent out a room. I don't think it does not apply to AB 1482 does not apply. So my question is, the lease agreement that she wants to use, she got from another landlord that is simply a roommate agreement, roommate lease. It's not very detailed. So my question is, even though she's renting out just a room, it's in a condo, it does not apply to AB 1482 doesn't apply. Does she still need that statement in the lease that says this rental agreement or this room in this condo does not apply to state rent control?
You must have that phrase in your contract. If you don't, then you are going to be subject to statewide rent control, AB 1482. You must include that. You might want to have her take my lease and then add in that roommate portion as an addendum to my lease. So she'll be very covered in terms of anything that might happen.
Understood. Thank you, Dennis.
My pleasure. Okay, let's move on to Marilyn. Marilyn, how are you? Marilyn, are you there? Please unmute yourself.
Yes, thank you, Dennis. I am. I have a situation with a new tenant who is an engineer for SpaceX, drives a new Tesla, makes $15,000 a month, and just sold or is in the process of selling his home in Florida. He was transferred. He on the lease, we allowed him to have one, he said, a medium-sized dog. He has moved in. He did issue, unfortunately, an out-of-state check to the manager, which was accepted, and then said that that account had been frozen, so he would vel cash instead. He owed, the check covered first and last month's rent and was or first in deposit, and was in the total of $6,400. He velled $1,100 and said he couldn't pay anymore. And it turns out that the medium-sized dog is 2 German Shepherds that he keeps in house the 12-hour period that he works, without their being taken out by anyone. So the dogs initially were barking at a cat across the way. And they're creating a problem. Also, they're relieving themselves inside because they can't wait 12 hours until he comes home to take them out. And I'm just wondering, with the bad check, is it possible to pursue him for fraud? And how do we? That would be my first question. Second question, since he did vel, though it was a much smaller amount to us, how do we not accept rent from him if he insists on velling again?
Okay, good questions. I wish I knew what your mouth looked like, so you adjust your camera. Pull that down a little bit, wherever your camera is, okay? All I'm seeing is your 2 eyes. I thought I was talking to a ventriloquist for a second there. Okay, first of all, the main issue is the guy's a thief, okay? He gave a bad check, okay?
Exactly.
And now he's telling you he can only pay you $1,100. I don't even know why he did that. Now he
Well,
tells you he doesn't
800, yes.
whatever. So obviously you need to bring forth an immediate eviction. The eviction should go on 2 reasons. Number 1, failure to pay the portion of the security deposit, failure to pay the first month's rent, and the fact that he has an unauthorized dog in possession of the premises. So I would be serving a 3-day notice for the rent, a 3-day notice, and a 3-day notice to perform or quit for the security deposit, and also for the pet. and proceed
Okay.
forward with an eviction. You have no other options. Is this a criminal action where I can call the police? Because God knows he was a thief. He knew he was going to be doing this, and God damn, this should be a violation of the law. And the answer is, yeah, sure, but nobody's going to care. They don't care about illegal aliens in this state, right? So in fact, what is this? It's a state that encourages illegal aliens and everything else. So, and unless you're killing somebody, and even then, I doubt that they're going to do anything, you're stuck with protecting your own rights. Now, shame on your management company for it's okay to take a personal check. So it's okay to take a cashier's check. You can wire the money, but if you take a cashier's check or a personal check, you do not give possession. You have to wait till those items clear first. So shame on your management company for taking an out-of-state check. And by the way, I even doubt that the guy works where he says he's worked, based on the fact that they was transferred. If the guy's making this kind of money, why would he be doing this? You rented to a thief, and you need to take immediate action to excise him from your building. You're going to take a big loss, and unless I represent that management company, I would seek compensation from them.
All right, and thank you. And in terms of his putting more money into through Vel, how do I not take?
Okay, well, that's not a problem. Everybody thinks that's a problem, that, gee, I start the notice, I filed the lawsuit, then he puts in $100, and now, oh my God, I've accepted rent. You haven't accepted rent if they Velled the money to you. First of all, with Vel, and I don't deal with Vel, I deal with Zelle, but I don't deal with Vel. But if you have to accept it, I believe. But even if it gets into your account, no problem. Whatever he sent to you, once it clears, you send your personal check back in the same amount with a little note saying you've made an unauthorized deposit into my account. So
Okay.
it's not a problem whatsoever.
Very good. Thank you, Dennis.
My pleasure. And we are going to move on. Susan Vicina. I'm going to ask you to unmute yourself. There you go. Uh-oh. Uh-oh, young lady. I'm going to ask you to unmute. Let me try that again. Unmute.
Okay.
There you go.
Can you hear me?
Perfectly.
Thank you. Thanks for taking my call. So first I have just a very quick question, because I was reading the May issue of Apartment Owners Association. You have a question number 5 related to what you just talked about in terms of the $200 of the Section 8 person who didn't pay their $200 a month.
Yes.
That doesn't apply just for Section 8 in terms of the fair market value, and it has to reach all that. It's for any tenant, right?
Any tenant. So if I've got a tenant, for example, that's a 1-bedroom going for $2,000, Section 8 has nothing to do with it. In the city of Los Angeles and unincorporated areas of LA County, regardless of what kind of a residence we're talking about, brand new single-family home, an apartment house built 35 years ago, you got to get above the threshold. So let's throw it back at these moronic elected officials by saying, okay, you know what? I can't start an eviction based on May's rent because I'm below the threshold, but here's a goddamn $50 notice to perform or quit for you to pay me the late charges. I will take that case. I will throw that person out.
Okay, so my actual situation in question is kind of interesting, because I'm a landlord. You've helped me with a lot of different issues and evictions and things, but I'm also a tenant. And so it's so interesting how many issues come up as a tenant that I learn about landlord stuff. So my landlord, where I've lived here for a long time, there's a spa amenity that's been in disrepair for over 3 years. Landlord refuses to decrease rent. So my question actually is that as it applies to Civil Code 1942.4 of the Civil Code, where it says a landlord of a dwelling may not demand rent, collect rent, issue notice of rent increase if all the following conditions exist prior to the landlord's demand or notice. And there's four scenarios that have to apply, and all 4 apply. In particular, that the Department of Public Health has been involved since March of 2023, and there's been at least 6 different notices.
Let me slow you down. I don't believe the fact that a jacuzzi doesn't work deals with the issue of habitability.
Oh, it went from green to brown to black.
But
to
again, the
mosquito-infected.
jacuzzi is in a common area of the property. You can walk into your unit, you can lock the door, you have heat, you've got probably air conditioning, you got hot and cold running water. It's not going to rise to that level. And what you need to do, I presume you're in the city of Los Angeles?
Yes,
Okay, what you need to do is you need to make a complaint to the Los Angeles Housing Department, and what you should ask for is a
it's not an
reduction in rent.
RSO building.
It's not an RSO building? Okay, then what I would do is, I wouldn't withhold rent for that, because again, I don't think it's a matter of habitability, but you made a bargain, okay, for this unit, and you're paying X amount of dollars, let's say $3,000, and the unit was a 2-bedroom with a jacuzzi, and you didn't get your jacuzzi. I would sue the person in small claims court for the amount of months that you didn't. Let's pretend that the value of the jacuzzi is $100 a month. So you've been there for 30 months. I'd sue him for $3,000. And you know what's going to happen when you get to small claims court?
What?
You're going to win. Do you know why you're going to win?
Tell me.
Every tenant wins in small claims court. I don't care what happens. They're always against us landlords. So you're going to win. So take the little bugger to small claims court. Tell the landlord that you got this advice from Dennis Block. Maybe he'll get scared.
Thank you, Dennis. I appreciate it. And I hope you feel okay from your fall.
Thank you. By the way, that was 2 MRIs later, which and I just was in that tube today trying to see how my knee was doing. But actually funny that you should say that. So, okay, so I fell Saturday night, everything, shoulder, knee, so 2 MRIs. But last week I still did 2 seminars and didn't miss a second from work. So, you know, it's a workhorse. Anyway, and still doing the Zoom meeting, of course, even on Memorial Day weekend when our office was closed. So anyway, thank you very much. David, I'm going to ask you to unmute yourself.
Can you hear me, Dennis?
I can, David.
First of all, God bless you. You know, you are the only attorney that I know that does all these things for free. And no one else, I believe, in state of California is doing what you're doing for us.
Thank you very much. And it's really truly a matter of love. We have all the business we need. And not that we push away business, but really, this is just really fun for me to do this. And I'm really trying to grow this channel just because I enjoy doing it, David.
Now, a question I have is that most of my tenants are on the old lease that has the wrong verbiage regarding the late fees. And some of the other tenants don't even have rental agreement. I would like to know, would I be able to do a change in term of tenancy to both of these regarding the new language for the late fees, the ones that have rental agreements, but all kind, and the one that don't even have any?
And the answer is, first, I need to know where is your property located?
Well, one of them is in San Bernardino County. The other ones are in LA County. The ones in LA County have no rental agreements.
Okay,
Of
when you
course,
say LA County, do you mean the city of Los Angeles?
no, we're talking about the Van Nuys, the North Hills. and
Okay,
that
that's all the city of Los Angeles. So the answer is no, you can't change the terms of a tenancy and then use that term to evict your tenant. With regard to the one in San Bernardino, I think you're okay doing that by doing a 30-day change of terms of tenancy to institute a proper late charge provision.
Thank you so much. That's all.
All right, David, thank you. Good question. And we are moving on to Diana D. I'm going to ask you to unmute yourself. Diane D, excuse me. If you're not there, oh, there you go.
I'm here, Dennis. Don't discard me.
No.
I'm glad you survived the MRI tube. I think that's worse than the fall, but
Oh my God, the banging in my head today at 9:50 in the morning, it was crazy.
oh, and yet you're here with us, so thank you.
Yeah.
I kind of what the gentleman just asked. So if I have I don't really have rental agreements, and they're just long-term things that, I don't know. But if I wanted to add in, do like a 30-day change of terms of rental agreement and add in things that are in your contract, such as the deposit, and like if they leave and leave stuff behind, I can discard it, those type of things. Do they have to sign that, or can I, if there's no change in rent, can I just serve that on them, and that becomes the new changes?
Okay, so first of all, a change of terms of tenancy is never signed by a tenant. You're just changing the terms. I'm raising your rent. They don't sign for that. So the issue is, yes, if your tenant is on a month-to-month tenancy, you can change the terms of the tenancy. But in most jurisdictions, you can't change the terms of a tenancy and then use that as a ground to evict. So for
Okay.
example, we'll take one off the top of my head. If your rental agreement doesn't have a late charge, then and you're in, for example, the city of Los Angeles, and then you institute a late charge, you can't use that if the tenant doesn't pay the rent. You can't use that to evict the tenant. But for example, a term that's in my rental agreement that any personal property left behind after you vacate, I can immediately toss it away. I don't have to go through the abandonment procedure as required by the civil code. That would be fine to do so.
So I did have like years ago, so before I think all of this stuff, well before COVID, I had raised rents, and I added in late fees. And so if I cleaned it up with your language, is that still something that wouldn't be enforceable if
Well,
they
yeah, it's not enforceable if you're going to use the change to
Mhm.
use that as an eviction. By the way, the City Council of Los Angeles wrote that into their statute many years ago because they were trying to prevent a Dennis Block tactic that we had employed many years ago, which we were very successful in evicting tenants by changing the terms and then using that to evict a tenant. It was a good strategy until they closed us down on that one. Anyway,
So
thank you very much, Diane.
I
And we are going to move on to, I'm going to go a little out of order here because I see a name and I want to see if it's a person that I know. And that is Amarino. I'm going to ask you to unmute yourself.
Hello, Dennis.
Oh, not the Amarino that I know, but
It doesn't seem like it, no.
how can I help you?
Just wanted to know what is the proper way to add someone onto a rental agreement and also to remove someone from a rental agreement? Is
I have
just
a
filling in?
form. Yeah, I have a form on my rental agreement on my website that allows you to kind of substitute tenants. So it's an easy form. You want to make sure though that that the exiting tenant, his security deposit has been accounted for, so that he waives his security deposit or he gets contribution from the new tenant coming in that would compensate him for the security deposit. Other than that, that form that's on my website is easy to fill out. Just be careful about the security deposit that you're letting one guy go and he says, hey, I contributed 50% of that security deposit. Where's my money? Make sure that you've been accounted for that.
Oh, okay. So just to make sure I understand this, if say there's a 2-bedroom apartment, there's 2 different people living in there, one of them leaves, someone has to replace them. It just can't be that the tenant, the person that's left in that unit, just takes over.
Oh, of course. Yes.
Okay.
That was different. I thought you were substituting a tenant is what I thought you said. No, if you rented to A and B moves out, A's there, A's responsible for the rent and B's responsible for the rent. They're both on the rental agreement. What you have to look at it is that a partnership rented your unit. A partnership paid the security deposit. When the partnership leaves, then both partners are not responsible. But the fact that B left, God bless him, he signed a rental agreement. He's got to give you back that place vacant.
Okay. Gotcha. So do I still have to fill out a form stating that he's no
No, fill
longer?
out
No,
nothing. They're both
nothing.
responsible. There's nothing for you to do. If you're going to have a substitute
Okay.
tenant move in, that's a different story.
I see. And what about adding a tenant instead of, say you have that's a 2-bedroom, and it's always been one person, and then all of a sudden there's another one moving in, and they're planning on
Yeah,
living in
yeah,
the
I would
second bedroom.
add their name to the rental agreement, just do an addendum that such and such
addendum.
person is joining the tenancy.
Got it. Okay, perfect. That's all I needed. Thank you very much.
Okay, let's go back in order here. I see it says here iPhone. I presume you're using it as Zoom on your iPhone, so if you want to unmute yourself. Otherwise, it's *6. iPhone, I'm going to ask you to unmute yourself. There you go.
Yeah, I'm muted.
Yes, you
Oh,
did good.
yeah. Hey, Dennis, can you hear me?
Perfectly.
Oh, man, I'm so glad to get on. I've been trying for 2 weeks. So,
You can always
but
call the
anyway,
office, you know.
oh, okay. I know now. Well, you kind of almost answered my question when you said landlords never win when you go to small claims court. But I have a tenant who's I'm in the process of evicting because she has a pet. And it's similar to your other caller. She leaves it in there all day to a point where the carpet is saturated. I had a guy come in and clean the carpet. It didn't do any good. It still smells. So I gave her a 3-day notice to get rid of the smell or clean it up. She hasn't done it. It still smells. So my question was, that carpet is going to have to be replaced. The floor is going to need to be sealed. It's a lot of damage. And you say, small claim court is useless.
No, I think that I'm saying generally when a tenant brings a landlord to small claims court, in those
Oh, okay.
situations, the tenant usually wins. That's been my experience.
Mm-hmm. Mm-hmm.
And by the way, if you're ever in small claims court and they have somebody there that they're telling you is a judge pro tem, a judge pro tem is an attorney who has nothing to do, so he donates his time to the court. Never take a judge pro tem unless you're a tenant. Also, if you're a commissioner, you do not have to accept a commissioner as the person who's going to hear your case. So you can say, I'm not stipulating to a judge pro tem. I'm not stipulating to a commissioner. I want a judge. And by the way, if you get a judge, ask for an old judge. The older they are, the more conservative they are. Do you know why old people tend to be conservative? And that's because the older you get, the smarter you get. Okay. All right. So I'm sure I angered some people out there, but who cares, really?
Yeah. Another part, I have a tenant that is really stipulating in the lease that she can store her plants 2 feet out from the building. And she just goes, she's out 3 foot. Now she's out 4 feet. And I keep asking her to move them back. I don't want to evict her because she pays her rent on time, but can I move those plants?
I think you can. She's storing your plants in the common area. She didn't rent that area. That's a common area. So I would tell her, look, I'm giving you 1 week. Get rid of the plants or they're going into the dumpster.
Okay. Okay. So I give her a 3-day notice, right?
No 3-day notice. Just give her a warning letter. Okay.
Okay.
You said you didn't want to evict her. So if
yeah,
you didn't
I don't
want to
evict
evict her,
her.
then we just give her a warning letter. Say, look, you got your stuff on my property. This is not your property. It's common areas. Move it or lose it. And with that, I'm going to move on. Thank you very much. Norman, I'm going to ask you to unmute yourself. Hello, Norman.
Hi, Dennis. Thank you for updating your rental agreement. It's really great, and I'd like to use it for an existing tenant. The existing agreement he has, it's over 20 years old, pretty obsolete, so I'd like to use yours pretty much in entirety. Can that still be done as an amendment to the existing agreement, or does it have to be a brand new agreement? And
what city, please?
Can the old, it's Lawndale,
so you're under, and I presume it's not a single family home?
it's a condo, and so it's
okay, so if it's
no
a
rent
condo,
control.
you're not subject to statewide rent control. So you have the right to ask him to sign it. I would demand for him to sign it. If he doesn't, then tell him that you're going to be figuring out ways to terminate the tenancy or raising the rent significantly, because you have that as your right.
Okay. And the old security deposit can carry over
Of course.
to the, okay. And he's been paying by PayPal, which works fine. He likes it, I like it. Can that be said in the rental agreement that?
Yeah, you
the
can put
payments
that
have-
provision in. You should also have a specific address where he can pay the rent to. Under California law, you just can't make it totally electronic. You can also have it paid to a bank account. That's permissible. So at least have one for a bank account or one for an actual physical address. But of course, he can also pay it by PayPal.
Okay, thank you.
All right, thank you, sir. Well, we have a lively show today. Let's move on to a regular. Janice, I'm going to ask you to unmute yourself.
Hi, Dennis. Sorry to hear about your mishap. I hope you heal soon. On this SB 567, I'm getting pushback from the property manager who says she is not responsible for including what I assume is standard car or AOA language, exempting single-family properties that are not LLCs, et cetera. That's not legal, is it? Don't property managers have to do that?
They have to follow the law. That doesn't mean that they do, you know.
Yeah.
Doctors don't follow the law, attorneys don't follow the law, but technically they have to comply with the law.
Okay, thanks.
Okay. All right, moving along to Iris Prasad. I'm going to ask you to unmute yourself.
Can you hear me?
Perfectly. Look at you.
Hi, Dennis. How are you?
I am fine, thank you.
Well, great. I've got a question. I filed a declaration for no fault eviction, and I served the notice for her to evict. She's due out July 1st. Now, she's paid last month's rent, and she owes me 1 month from last year that she didn't pay rent. If she happens to make that June payment, can I take it as that payment that she didn't make in April 2023? Or would that expose me to not being able to get her out? Because she may not leave on the 1st.
Yeah, I wouldn't take the chance, because people are going to interpret it that she is paying for the June's rent. And even though I don't think it is, you know, not only do we have to follow the law, we have to follow like the positions that these judges take. So you just don't want any trouble for yourself on this. It's just not worth it, because obviously you're really attempting to rid yourself of this tenant to have, I presume, a family member move in?
Me.
So yourself move in.
I'm in Florida right now, so I'm coming back to LA.
You look so local right now to me.
A lot of sun. One last thing, Dennis. She's been smoking inside of the house. It's evident. Everyone that walks in can smell it. She denies that she's smoking. And would I be also, if she does not leave on July 1st, I can evict her on the no fault eviction for her not complying, correct?
Correct.
And all I would have to prove is that she didn't leave after the 60
Right.
days.
I mean, you don't want to start another notice for smoking. And by the way, the smoking notice would be 3-day notice to stop smoking. So if she stops smoking after the 3rd day, where are you? And you've just ruined your 60-day notice to vacate because you want to move in. So just let that lie. How you're going to handle the smoking is that every penny of the security deposit is going to be eaten up for cleaning, because cleaning means that you're going to have to do a deep clean of that area because of the smoke.
Okay, Dennis. So if she doesn't leave on the 1st, I will be contacting you for an unlawful detainer, correct?
I will be there. Trust me, to take your call.
And that money that she has there, she's got $19,150 in escrow. Would I be able to use that to pay you?
No. That money, whether she moves timely or not, has to sit in escrow. And if she hasn't taken the money out now, I can tell you categorically, you're going to be calling me. So let's do it on an easy case. So hopefully you did all your paperwork correctly. This is the city of Los Angeles.
Yes.
Hopefully you
rent
have
control.
all the notices posted on the property that you were supposed to post.
Got him.
And when you did do the 60-day notice after you filed your declaration with LAHD, I hope you also sent a copy of that 60-day notice to the city of LA with their eviction cover sheet.
I did, and I have the proof that it was filed.
Very good. Okay, very proud of you.
Well, thank you. I will,
You're
hopefully I may not see you for that.
making my case easy.
And that's because you taught us. Thank you so much.
You're very kind. Nice talking with you. Okay, let's move on. We have so many callers today, and our time is looking good. Let's move on to Razzo. Razzo, I'm going to ask you to unmute yourself.
Okay, so question is, if I'm trying to evict a tenant in Los Angeles RSO and I lose, can I still do the relocation for that unit if there's a comparable unit?
I'm not following your question. You say you brought a case and you lose. What was the case brought upon?
For nuisance.
Okay, so you were trying to evict this tenant because other tenants in the building were complaining that he was making interferences with their comfort and enjoyment of the property. So now you're saying, hypothetically, you lost that case. Now you want to bring forth another case. What's the other case based on?
Can I still do the relocation payout? If there's
Relocation for
similar-
what? Relocation is not triggered unless you have a reason to evict.
For a
Once you have,
family member, a no-fault eviction?
yeah, then you could do a family member eviction. Family member has to either be grandparents, your parents, yourself, your spouse, or domestic partner, your children or your grandchildren. So if it's one of those, then technically you could do so.
Even if there's a comparable unit, same one bedroom?
If there's a comparable unit in the building, the answer is no, you can't. So
Okay.
you better win on this nuisance case. So bring every tenant to court, drag them there, or subpoena them to come to court so that they'll testify how their life is miserable because of this person.
Okay, thank you.
Thank you, Razzo. Good question. And we are moving on to, I presume, a doctor or somebody whose name is MD. I'm going to ask you to unmute yourself.
Hi, thanks for help and your time.
Thank you. Are you a doctor, sir?
No, just
Are you?
I'm glad
You're just Michael Dennis. That's all.
I'm planning to add the ADUs at the back of my property, and I'm gonna lose the parking spaces. So the problem is I don't have the separate lease agreement for the parking space with the tenants. I want to know if I can eliminate the parking spaces from.
And as I always say when I start to answer the question, what city is the property located in?
LA and non-RSO.
Okay, it's non-RSO, but it is in LA. If you're going to take away a parking spot or garage where a tenant had it at the inception of the tenancy, then you're going to have to do a decrease in rent. So give them a corresponding decrease in rent. So if a typical garage parking spot would cost $70 or $100 in your area, then I would reduce the rent by that amount.
Okay. Thank you so much.
All right, you take care.
I appreciate it. Thank you.
Okay, we're going to move on. Actually, you know what? Before we move on, let me rethink that. If your property is not under RSO, I presume it was 15 years. You can come back on if you want to unmute yourself. If it was less than 15 years, you wouldn't be under any rent control, so you could do a straight change of terms of tenancy. Otherwise, if it's more than 15 years old, and I presume it is, so it was like built in the 80s or something, or the 90s, then you're under statewide rent control. And under statewide rent control, they really don't have a provision for this, but as I'm analyzing it here and thinking about it, I think you would have to still give us corresponding decrease in rent. All right, anyway, thank you.
New construction.
What's that?
It's a new construction.
Right, as to your existing property is new construction?
Yes, it's fourplex new construction.
Okay, and are the tenants on month-to-month or lease?
and months.
Then just serve a 30-day notice, and you don't have to do any giveaway of a reduction in rent. I'm just changing the terms of your tenancy because I have no rent control that's telling me what to do. In other words, you have a civilized piece of property. Thank you very much. And we are moving on to Suzette. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello, Suzette.
How are you?
I am good, thank you. It's Saturday.
All righty. So, is there a specific deadline after you serve that itemized 21-day security deposit, and you find more damage? Can you send a supplemental or?
I mean, I guess you could. You can always sue a tenant for damage to the unit, whenever you found out about that damage. But if you've already sent the security deposit itemization, then either it showed that the entire security deposit was already expended, or you gave a check. Well, the tenant's not going to give you back part of the money because you found additional damages. So you'd have to sue them in small claims court, Suzette.
No, they don't. They actually owe me money because they weren't paying rent. So
Right.
that
So the security deposit itemization showed X amount. Now you're saying, well, actually, I found more damage. You're going to have to sue them in small claims court anyway, for the difference, since the security deposit didn't cover it. So you can just add on additional charges. I would send the tenant an additional letter saying, hey, you know what? I found some other damage that you caused. Thank you very much. We're going to be seeking those damages as well. Thank you very much, Suzette. And now we're going to take our last caller. Let's make it a good one. Gus, I'm going to ask you to unmute yourself.
Hey, Dennis, can you hear me all right?
You look very good, Gus.
So just a quick question here. I'm about to file a complaint, UD complaint. It's for non-payment of rent. And I do see the option that you don't have to include the lease, but should I include it anyway?
I don't think there's anything to hide, so might as well include it anyway.
Got it. And then one more question. For a summary judgment, what's your take on that? Is it good to do it as soon as an answer is filed?
Well, it's not as soon as an answer is filed. I mean, you want to do it if you have the legal right to do so. Filing a summary judgment does cost money. The filing fee alone is over $500. So you want to make sure that you have the correct elements to file it. For everybody out there, what is a summary judgment motion? Well, if the tenant has been served with the eviction lawsuit, or any lawsuit, by the way, and then the tenant answers the lawsuit. So now you have a contested matter, and we're going to need to request a trial and actually have a trial in front of a judge or in front of a jury. But sometimes what would be the case if in the tenant's answer, he checks off the box that says, everything in the complaint is true. I've got no defenses. Well, if he checks something like that, or he just didn't check anything, then in that situation, there really is what they call no triable issues of fact. And if there's no triable issues of fact, then technically we don't have to have a trial. So we would file a motion for summary judgment. The tenant would have the right to oppose that. There'd be a quick little hearing. And if the judge found that there were no triable issues of facts, then you would win automatically, unless it was a kangaroo court.
Exactly. I see. So it just depends on what they checked off, and usually it's about everything, right?
Yes.
So, all right. Appreciate your help, Dennis.
Very good. Well, thank you. Well, thank you, everybody. I think we had a great show today, if I do say so myself. And remember, every Saturday at 3 p.m., you can join the Zoom meeting or follow us on YouTube Live. Also, within about an hour or so, because I am the consummate video editor, I'll have this up on my YouTube channel, which is, you can get there through my website, evict123.com. Look for the previous shows. And once again, I want everybody to have a happy Memorial Day weekend. Stay safe. And last, whatever you do, don't fall. Thank you, everybody. you.